If you came to the United States fleeing persecution in your home country, well, you've got a long, challenging road ahead of you. The path to asylum is difficult, but with perseverance and the right help along the way, achieving your dream of winning asylum and building in America the life that you deserve, well, it may be in the cards for you. But first things first, you need to know what lies ahead of you. And in this training, I'm going to walk you step by step through the process of seeking asylum in the United States for people who are in immigration court proceedings. So if you came on a visa and you've never gotten a letter from the government saying that the Department of Homeland Security is trying to deport you, then your process will be with the immigration agency USCIS. And that process is different from what I'm explaining in this video. This video is for people who are in deportation proceedings in immigration court. Stick with me to the end of the training because understanding each of these steps is crucial to your asylum success. I'm Brian Manning, and I used to be an asylum officer with the government, but now, as an asylum lawyer, well, I help immigrants all over the country to secure their future in America through asylum. All right, we're gonna walk through what happens in an asylum case for people who are in immigration court proceedings from start to finish. Now, to do that, well, let's jump over to my computer.
All right, in this tutorial, we're going to walk through the 6 steps for pursuing asylum in the United States if you've received a notice to appear from the immigration authorities, which is the document that says that the government is trying to deport you and you need to show up in immigration court to defend yourself. Once this document, referred to as an NTA for its initials, is filed with the immigration court, you are in deportation proceedings. You may also hear this process be referred to as removal proceedings. So the government is trying to deport you, and you'll be applying for asylum as a form of relief from removal. They call this a defensive asylum case because you're seeking asylum as a defense to deportation. Let me tell you what the 6 steps are, and then we'll go through and discuss each of them in more detail. The first step is applying for asylum. Step 2 is having a biometrics appointment, and step 3 is applying for a work permit. Next, at step 4, we've got your first hearing in immigration court, followed by your second main asylum hearing in immigration court, which is step 5. Step 6 is getting the decision in your case. And finally, what happens after you've gotten the asylum decision? So that's where we're headed. Let's get started. Okay, step 1. First, you need to apply for asylum. This involves formally filing an asylum application form with the government. I want to be clear about this. The discussion that you might have had with an asylum officer that resulted in some documentation saying that you had received a positive, credible fear determination is not the same as applying for asylum. The credible fear process that many people go through is just a step on the way toward even being allowed to apply for asylum. Doing that interview, which often occurs while you're detained and is usually done by telephone, does not absolve you of the requirement to apply for asylum. So, how do you apply for asylum? Well, you'll need to fill out Form 1589, Application for Asylum and for Withholding of Removal. You can find the current version on the website of the immigration agency called U.S. Citizenship and Immigration Services, which is known by its initials, USCIS. The form is fairly long, but most of the information requested is biographical in nature, things like your education, work history, and the like. But there are a handful of substantive questions where you have to indicate what's happened in your country and why you're afraid to return there. You don't have to be super detailed in the application, but you should take care in framing your case. The application is a chance to frame your case and set you up for success later on. And some of the questions can be tricky. I do definitely think it's best to hire an asylum lawyer for help with this, but I realize that's not an option for everyone. For folks who can't hire a lawyer, I've created a very detailed video training all about the asylum application form where I walk through pretty much every single element in the application. I'm going to leave a link to that training in the description of this video. Listen, this form is the cornerstone of your asylum request. It sets the stage for everything that's to follow. Not doing it well can really cause problems later on. I've seen cases ruined and deportation orders issued because of avoidable problems in the applicant's asylum application. This is not the kind of thing you want to rush through or do half-heartedly. You've got to take it seriously, okay? Another word of caution, absolutely do not hire a so-called document preparer or immigration assistant to help with your asylum application. Non-attorneys who take money to help with an asylum application are breaking the rules unless they have a formal designation from the immigration court system that allows them to do this. In fact, the unauthorized practice of law, which is what this is actually a crime. You don't want to get tangled up in this. Also, most of these people have no idea what they're doing and can really mess up your case. I can't tell you how many times I've seen an otherwise solid asylum case torpedoed because the person used one of these non-attorney preparers. Stay away from this. Okay, moving on. What about supporting documents? Do you need to provide those now, along with the asylum application form? Well, I recommend waiting on things like evidence and a declaration until later. We'll discuss this at Step 5, which concerns your principal asylum hearing. If you're married or having children and you want to include them in your case, you should provide with your asylum application copies of your marriage certificate and birth certificates for your children. Note that if these are in a language other than English, they'll need to be translated into English, and the translations must contain a special attestation by the translator. You should include a copy of both the foreign language original and the English language translation. This is true not just of marriage and birth certificates. Any item you want to submit to the court that's not in English must be translated into English and contain a translator's certification. I strongly advise that you use a professional translator with experience translating in asylum cases. Okay, how do you submit your completed asylum application? You need to send it to the immigration court handling your case. You can either do this by mail or in person, at the window in the immigration court where their staff deal with the public and receive filings. Either way, by mail or in person is fine. Or, at the time I'm making this video, there's no way for people who don't have a lawyer to file their asylum application online, unfortunately. But for people who do have a lawyer, the lawyer can submit the application online through a portal the court system has for attorneys. Now, in addition to submitting the asylum application to the court, you've got to send a copy to the government prosecutors assigned to your case. There's a unit within the Department of Homeland Security consisting of attorneys who are trying to show the judge why people in immigration court should be deported, and you're responsible for making sure they get a copy of anything you file with the court, including your asylum application materials. This also includes evidence and your declaration. So, how do you go about doing this? Sending a copy of your asylum filing to the government attorney. Well, there's a specific office that covers each of the immigration courts, and you need to find the address for the Office of Prosecutors assigned to your court. Probably the simplest way to do this is to either call your court and ask about it, they can tell you, or to go in person to the court and inquire. You can just say, "Hey, I know I need to send a copy of my filing to the government's lawyers. Could you please tell me the name of the office to whom I should address my mailing, as well as their address?" You can also find this information online. Okay. 2 more quick things on the asylum application before we move to the next step in the process. First, you need to submit the original version of your application to the court and make a copy to send to the government prosecutors, as we just discussed. But then another copy for your own records and yet another copy for purposes of getting your biometrics appointment scheduled, which we're going to discuss in just a second. So we're looking at an original plus 3 copies. Second, there's a strong motivation to apply for asylum as quickly as possible. You see, the sooner you apply for asylum, the sooner you can get your work permit. More on that at Step 3 in our tutorial. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and bell notification so you don't miss the insights that I share on this channel. Okay, we're ready for Step 2, which is the biometrics appointment. Remember how I said a second ago that you need to make a copy of your asylum application for purposes of getting your biometrics appointment scheduled? Well, you don't actually need the whole application for this purpose. You just need a copy of the first 3 pages of your asylum application. You'll take those 3 pages and send them, along with a certain document published by the government, to the USCIS office that handles biometrics issues. You can get this document, which contains the address to which you'll need to send this stuff, and lets them know that you're asking for a biometrics appointment to be scheduled on the USCIS website. Also, the judge will make sure you get this document and information about requesting a biometrics appointment during your first hearing in immigration court. But I want to be clear about something. You do not need to wait for your first court hearing in order to apply for asylum. You can apply for asylum at any time, including before ever having any hearings. And again, the sooner you apply for asylum, the sooner you can get a work permit, so you really shouldn't delay in filing. Okay, so what is this biometric stuff all about? Well, this is an appointment where the government will take your photograph and fingerprints, which are used in background checks that are required for all asylum seekers. They want to know if you've done anything that could mean you're dangerous, or have perhaps done something that could make you ineligible for asylum. After you send the first 3 pages of your asylum application to the proper USCIS office, they'll send you a notice telling you that your biometrics appointment has been scheduled. This letter usually comes a few weeks after you send in the request for the appointment, and the appointment itself normally occurs within a week or 2 of the time that you receive the notice. On the day of your appointment, you'll go to a USCIS Application Support Center, which is just a normal government office. You'll show them your appointment notice, and they'll take your photograph and fingerprints. Very straightforward. They will not ask you questions about your underlying asylum case or anything like that. This is easy. You do not need a lawyer to accompany you to this appointment. Note that family members whom you've included as dependents in your asylum claim will have to go to this appointment too, except for children who are under 14 years old. They're exempt. Alright, before moving on, let me note that the order in which you'll face some of these steps may be different than the order I'm presenting today. There's some fluidity here. For example, what we're going to talk about now, at step 3, applying for a work permit, could actually happen after the next step on our list, which is the first court hearing. But to be sure, you will likely encounter all of these steps at some point in your asylum journey. Okay, with that, we're ready to talk about the work permit. This is formally called an Employment Authorization Document and is often referred to by the initials EAD. Permission to work legally in the United States is, of course, massively important. It'll allow you to support yourself. You're likely going to get this precious document about 6 or 7 months after submitting your asylum application. You're eligible to apply for your EAD once your asylum application has been pending with the government for 150 days. That's around 5 months, right? And then it usually takes USCIS a month or two to process the application and actually send your work permit card to you. Good news. This is free for first-time applicants who are seeking the work permit based on a pending asylum case. When you go to renew your work permit in the future, you'll have to pay a processing fee, and it will likely take the government a very long time to adjudicate the renewal request. But for first-time applicants, it's free, and you get an answer quickly. So, how do you apply for a work permit? Like the biometrics appointment, this process is handled not by the immigration court system, but by USCIS. The form you need to fill out is called Form 1765, Application for Employment Authorization. You can find this form on the USCIS website, but it's best to apply online with USCIS. To do that, you'll need to create an account in the portal called My USCIS. But that's easy. The work permit application form is pretty straightforward, much easier than the asylum application form. Note that when asked to indicate the category that makes you eligible for a work permit, you'll want to select the option C8, which is for asylum seekers. Okay, we're ready now to get into the court hearings, starting at step 4 with the first hearing, which is called a master calendar hearing. Weird name, I know. You'll be informed of this hearing through a letter from the immigration court. There should also be a date and time for the hearing set out in your notice to appear, but that date seldom sticks. The courts usually change things up, such that very few people end up having a court hearing on the date indicated in their NTA. If you get a letter from the immigration court with a date different than what's on your NTA, go with the one set by the court. Note that you can also check your court status either by calling a hotline that the courts have set up for this purpose or by checking online. There's a court website where you can find your next scheduled court date. For both this website and the hotline, you'll need your A number, which is a 9-digit number that the government uses for people in the immigration system. It's like a unique identifier for you, and it's found in every letter or other document you receive from the Court of the Department of Homeland Security. I recommend that you check the court website often, at least monthly, to verify your hearing status, because this often changes without notice. Sometimes the court fails to send the letter about a changed hearing date. You and any family members included in your case will need to appear in court at the designated time, where you'll wait with a bunch of other people in deportation proceedings for the judge to call your A number and name. When they do that, you'll go up and sit at a table across from the judge, and a lawyer from the government will be at a table off to your side. If you're not fluent in English, you can carry out the hearing with interpretation. There will almost certainly be a Spanish language interpreter in the courtroom, and if not, there'll be one participating by video conference. The judge can call up interpreters for other languages as necessary to join by phone or video conference. I strongly recommend using interpretation for your court hearings if you're not extremely comfortable in English. Communication is incredibly important in these hearings, and it's much better to use interpretation than to struggle with English or be worried that you may miss something. If you have a lawyer, this is a decision you can make with them ahead of time, whether to proceed in English or with interpretation if you're pretty fluent in English, but not positive that you're fluent enough. Okay, so what is this master calendar hearing all about? This is a preliminary hearing where the judge will review your case and set a timeline for future hearings. At this hearing, you'll confirm your contact information, address any preliminary issues, and schedule your individual hearing, which is the main hearing, during which you actually explain your asylum case. One of the main things the judge will do at this first hearing, the master calendar hearing, is to review with you your notice to appear. They'll ask whether you admit to the things that the government is alleging in it and whether you agree with the government's assertion that you're eligible to be deported. The judge will also ask you whether you want to seek so-called relief from removal, which includes asylum. The judge might also ask if you have an attorney or need more time to find one. If you say you'd like more time to find a lawyer, then the judge will almost certainly stop right there, discontinue the hearing, and schedule a new master calendar hearing, likely in the not-too-distant future. But I've got to tell you something very important. If you've already applied for asylum, but did so fewer than 180 days before your hearing, and the judge postpones your master calendar hearing so that you can have some time to find a lawyer, the so-called work permit clock that's counting up to the 180 days required for USCIS to approve your work permit application will stop counting days. It will freeze, and it won't start counting days again until you actually complete the master calendar hearing, which could be several months, or in rare cases, over a year in the future. What does this mean? Well, it means that by pausing your proceedings, you're impacting your ability to get a work permit unless you've already filed for asylum and did so at least 180 days prior to the date on which the judge pauses your proceedings. This is considered an applicant delay in the court process because you asked to reschedule a hearing. The upshot is that you should think seriously about requesting more time to find a lawyer if you've filed for asylum, but your application has been pending fewer than 180 days at the time of your master calendar hearing. Last thing on the master calendar hearing, people always ask whether they need a lawyer at this stage, and I think that yes, you should definitely have a lawyer with you for this hearing. It's true that in a majority of cases, this is a pretty simple hearing. But for sure, surprises can crop up at any moment, and there are definitely things that can happen that can hurt your chances for asylum success if they're not handled expertly at this stage. All right, we're ready to talk about Step 5, the individual hearing. Another weird name, no? This hearing is also referred to sometimes as a merits hearing or a hearing on the merits. It's the one where you really fight your case, where you tell your story and explain why you're qualified for asylum. This hearing could take place as soon as a couple months after your master calendar hearing, or it could be much further out. It could be many months or even years later. As I mentioned, you're normally notified of this date during your master calendar hearing. Okay, before turning to what happens at the individual hearing, let's touch briefly on evidence. You no doubt know that the right evidence can really lend credibility to an asylum claim, increasing your odds for success. So, if you're able to come up with documents that back up your case and which you want the judge to consider, how and when do you submit them? First, know that you can't just show up with evidence on the day of your individual hearing. You need to submit it ahead of time. Sometimes the judge makes an order, either during the master calendar hearing or thereafter, in a written order that's mailed to you, saying you need to submit any documents you want the judge to consider by a certain deadline. Sometimes that's 30 days before your individual hearing, or it could even be 60. If the judge does not make a specific order regarding this, then you must submit any evidence at least 15 days before your hearing date. That's the default deadline, 15 days. If you have a lawyer, they'll of course submit this for you. If you're doing it on your own, then you can either mail this packet to the court, or you can take it to the court and deliver it by hand at the clerk's window. And just like we discussed with the asylum application, you'll need to send a copy of this packet to the lawyers for the government, the prosecutor's office. All right, we're ready to talk about what happens on the day of your individual hearing. When you arrive at your asylum hearing, you'll enter the courtroom and be instructed to sit at a table positioned in front of the judge. The prosecutor, who represents the government and is seeking your deportation, will be seated at a separate table nearby. If you have legal representation, your attorney will join you at your table. The courtroom will be closed to the public, with only essential participants present, such as the judge, the attorneys, an interpreter if needed, and possibly a member of the judge's staff. As the judge enters, you should stand as a sign of respect. The hearing will begin with the judge introducing themselves, outlining the purpose of the proceedings, and confirming that you comprehend the process and your rights. Thus far, sounds like the preliminary hearing, right? The judge will then review your asylum application with you, allowing for any necessary updates or corrections. Once the application is finalized, you'll be asked to sign it, attesting to its accuracy, and take an oath by which you're promising provide truthful testimony. By the way, if English isn't your first language or you feel more at ease testifying in your native tongue, the court will provide an interpreter at no cost to you. Okay, next, you'll provide your direct testimony either from your seat or from the witness stand, as directed by the judge. This is your opportunity to share your story, detailing the experiences and fears that compelled you to seek asylum. If you have an attorney, they will guide your testimony through strategic questioning designed to demonstrate how you meet the asylum requirements. If you don't have legal representation, the judge will steer your testimony by asking questions. You see, you don't get to just sort of provide a narration. this is a question and answer session. The rules for asylum are complex, but it basically boils down to this. To win asylum, you must demonstrate that you have a well-founded fear of future persecution, and that this persecution would be motivated by the fact that you possess one of the 5 protected characteristics under U.S. asylum law: your race, religion, nationality, political opinion, or membership in a particular social group. The judge will seek to determine if any harm you suffered in the past is sufficiently severe to qualify as persecution under U.S. law, if there is a real risk of serious harm in the future, and if your persecutors are motivated by one of the protected characteristics. Those are the main things the judge will be asking you about. Other factors may also be considered, such as the possibility of safely relocating within your country or potential bars to asylum. Be prepared for a wide range of questions covering all aspects of your case. Okay, so what happens next? Following your direct testimony, the prosecutor will have the opportunity to cross-examine you, challenging your credibility and consistency. This can be an intense experience, as their goal is to undermine your case and persuade the judge that you don't qualify for asylum. Some prosecutors may adopt a hostile or intimidating approach to rattle you so that you'll make mistakes. Your testimony, including both direct and cross-examination, can last several hours and be emotionally and mentally taxing. If you feel overwhelmed or exhausted, you can request a break to compose yourself and prepare to continue. During your testimony, be ready to answer questions about any evidence you've submitted, as the judge or prosecutor may inquire about it. Additionally, the judge might interject at any time with questions that seem unrelated to the current line of questioning. It's essential to answer their questions directly and then be prepared for the next one. After your testimony concludes, any witnesses you've called may also testify and face cross-examination, although most asylum applicants don't have witnesses. In some cases, however, witnesses can provide valuable support to an asylum claim. Finally, you or your attorney will have the chance to make a closing argument, summarizing why you meet the criteria for asylum and addressing any key issues that could influence the case's outcome. The prosecutor can also present a closing argument. So that's the process for your individual hearing in immigration court in your asylum case. But how long does all of this take? All told, you can expect your asylum hearing to last at least a couple hours and more likely several hours. Sometimes you don't even finish the hearing in a single day. The judge has to schedule a follow-up hearing. You should definitely clear your calendar for the entire day on the date of your individual hearing in immigration court. Alright, at this point, you've done your job and the case is in the judge's hands. The judge will either announce their decision or inform you that they need time to consider it and will issue a written decision later. In most cases, the judge tells you the decision right then and there. Some judges will explain their reasoning in detail, while others give you virtually nothing in the way of insight into their thought process. If the judge says they're going to mail the decision to you, there's unfortunately no telling how long that might take. It'll likely be weeks, maybe even months, or perhaps even longer. Okay, finally, let's talk about what happens after you learn of the judge's decision. Regardless of how the decision is communicated, it's not final for 30 days. Both sides have the right to appeal within this period unless they waive this right. If the judge announces the decision at the end of the hearing, they'll ask both you and the prosecutor whether you want to reserve your right to appeal the decision. If you don't get the decision you wanted, then I encourage you to say that yes, you reserve the right to appeal. You'll then have 30 days to file an appeal with the Board of Immigration Appeals, known as the BIA for its initials. If the judge gives you asylum, that decision isn't final unless the prosecutor waives appeal at the trial. Sometimes they do this, but not always. If they don't waive appeal, then you've got to just wait. The prosecutor has 30 days to file an appeal. If they do file an appeal, you'll get a letter notifying you about it, and you'll need to keep fighting your case. If you get to day 31 and the government hasn't appealed, then your grant of asylum becomes final. Let's step back and look at the overall timeline for seeking asylum in immigration court. Throughout these stages, timing varies. After filing Form 1589, receiving your biometrics appointment typically takes a few weeks. The master calendar hearing might be scheduled several months later. Following this, the individual hearing could be set many months to years into the future, depending on the court's backlog. If an appeal is filed, the BIA reviews the record from the immigration court and the arguments from both sides. You'll be given a deadline to file a legal brief. You should definitely get an asylum lawyer for this. The BIA does not hold a new hearing, but instead makes a decision based on the existing record. This process can take several months to over a year. The BIA can uphold the judge's decision, overturn it, or send the case back to the immigration court for further proceedings. If you get a negative decision from the BIA, there's yet another appeal you can make, this time to a federal court of appeals, such that you can keep fighting your case, probably for years. If you win your asylum case, like if the judge grants your asylum claim and then the prosecutor either says they're not going to appeal, or they reserve the right to appeal but then don't actually do so in the next 30 days, then you're on the road to permanent residency. You're eligible to get your green card 1 year after winning asylum, and then you can apply for U.S. citizenship 4 years after getting your permanent residency. So that's it, folks. That's the overview of seeking asylum in the United States for people who are in immigration court proceedings.
Congratulations on making it to the end of this very detailed tutorial on what you can expect as an asylum seeker in immigration court. If you're ready to take the next step and get help with your asylum case, then call my office today. That number is 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you live. Call us today and schedule an asylum strategy session so that we can help you secure your future in America through asylum. Again, I'm Brian Manning. It's an honor to serve you in your asylum journey.